in that position, take out the written change order requirement. It only hurts you. It doesn't help you. Because it's always going to be the owner that says, hey, I didn't authorize that. Oh, I didn't agree to that amount. It's better to get everything signed. I tell everybody, keep change order forms on your trucks. Nobody does it. I mean, I understand the practicalities and the realities of doing business. Maybe you may not have somebody there to sign. But then if the timing doesn't allow it, then don't do the work right away. Do the change order the next day and say, I want additional time because you delayed me, plus I want the additional expense, and this is how much it's going to cost, prior to doing the work. Otherwise, you may have a real problem of collecting. But if you're okay with that and assuming the risk and saying, hey, you know what, the owner's a great guy. They may be a great guy today, but you know what, they may have other bills to pay tomorrow. So rethink the way you do business. Give those change orders up front. If you have, it's unfortunate that you have to be mentally prepared that, hey, I may not get paid, but that's the business that we're in. I mean, quite frankly, that's why I actually went to law school and don't do contracting anymore. You almost have to be, it's not even fair, you almost have to be half of a lawyer today, even just to do business. There's so many documents and so many forms. And then there's going to be people like me out there looking for a way to get around it if I'm representing somebody against you. So I'm telling you how to protect yourself. Choice of forum, dispute resolutions, and attorney fee clauses. Number one, choice of forum. In the state of Florida, if you're a contractor and the project's in Florida, then the dispute has to be litigated in Florida or argued in Florida. There was once a forum clause in a contract that said that it was in the that any and all disputes will be decided and the only venue will be proper in the island of whatever it was called. Well, this was an island that floods itself about 7 times a year and that there's no inhabitable life there. Well, that wasn't held to be enforceable, but obviously you can see that they were trying to get around actually having any cases decided anywhere against them. Dispute resolution procedures. I want to talk to you a little about this. When I talk about dispute resolution, I'm talking about these AAA clauses, the arbitration clauses. I'm going to go argue one at 2 o'clock. I've got a hearing on that today, where it depends upon what the case is about. I may want it in arbitration. I may not want it in arbitration. How complex is the issue? Do I want this to even be public? Do I need people who are really going to understand the issues, or do I really want to confuse the issues? It's going to depend upon whether I want a jury to decide this, do I want a judge to decide this, or do I want an arbitrator to decide this? So my contracts specifically say that the contractor has the sole and exclusive right to determine whether or not this case or controversy will be determined in an arbitration. Well, that's what I use. I use it, and it's been held enforceable in one case. Avid Engineering, it's a 5th District Court of Appeal case. I got it from there. I said, that's great. And I've even modified it to be even better than that. It's something I never even thought about. Why shouldn't I be the one to decide whether or not we go to arbitration? I don't know right now if you get into a dispute 3 years from now whether or not I want that to be an arbitration or if I want it to be in a trial. Why should I have to decide? And what if they counterclaim something against you? How am I supposed to know right now whether or not I want that to be? It's not fair. So that's why I have clauses drafted up that say, and then if to the effect that they file a counterclaim against you, my clauses say, then we have 20 days to choose thereafter to determine whether or not we want to elect to go into arbitration. That way I get to know, I get to pick, I get to see. What if they're suing you for fraud? Or what if they want to start a class action lawsuit against you? Good luck now if I'm electing an arbitration. A lot harder. Well, next thing, and then it's not public. Another thing that you should know about arbitrations, though, I just want you to realize this, they are expensive. There is a fee to be filed prior to even going into an arbitration, sometimes they're $2,500, sometimes they're $1,200. Depending upon how much you're alleging is due, it could be even more than that if you're alleging multiple millions. And also, these arbitrators, they don't work for free. They actually get paid by the hour, the same way your attorneys get paid by the hour. So I just want you to be aware that you'll also be billed for those arbitrators' time as well. Next thing. Attorney fee clauses in the state of Florida. If you have it's very difficult to get attorney's fees if your contract does not have an attorney fee clause. The only way in the state of Florida to really get attorney's fees that are applicable to you anyway is if there's a statute that says that you're entitled to it. By the way, the lien claims all lien claims, whoever the prevailing party is entitled to attorney's fees if you're enforcing a lien. But if, let's assume that you've blown your lien rights, let's assume that this is just a breach of contract claim, then I'm going to be looking to the contract, I'm going to be seeing, is there any place in the contract that says that either party, I don't care who it is, either party, if either party prevails, let's assume it says the owner, let's assume it says the general contractor, I don't care, pick one. It says if that person prevails, then that person will be entitled to attorney's fees, it's deemed to be reciprocal. So I don't care if it says if the general contractor prevails and the general contractor only will be entitled to attorney's fees, the owner will also be entitled to attorney's fees. 57105, it's deemed reciprocal. Okay? Indemnification clauses, briefly, I just want you to know that a lot of these are held are struck. There are these clauses because there's a statute that makes it so difficult to actually draft these things. It usually takes me about a half a day just to draft these indemnification clauses. There has to be a monetary limit as to the amount of the indemnification, and it just has to. It's kind of a little bit difficult to write, but and I think it's up to $1 million, in fact, so it almost defeats the purpose. But if they're in there, try to strike them out. If not, then I guess you're stuck with them. Next page, I'm just going to go through real quickly. Documents required for payment. Just be aware that there are some documents here that may be requested of you prior to being entitled to payment. Read your contracts. If your contract says that prior to requesting payment, you have to show a certificate of liability insurance that's updated, workman's comp, give a partial release of